Hey everyone, welcome to lecture 3 where we cover your civil liberties or the Bill of Rights. I think this is a rather popular lecture based on absolutely nothing because this is an online class and I get no feedback. But I get a sense that maybe some of you guys find this a little bit more interesting than some of the other stuff. Brings in some relevant sort of court cases and sort of it serves as an introduction to the federal court system as well, which will be good for when we discuss the courts here in a few weeks. So let's go ahead and get started. So we talked about the anti-federalists said, all right, we'll ratify your constitution if you basically give us an opportunity to create a Bill of Rights, essentially establishing like basic freedoms. Let's put it in writing, make sure it's there to protect individual liberties. So James Madison researches these concerns and he proposes 12 articles to be included within the Constitution. But you say, Professor Strickland, there's only 10. Well, the first 2 actually didn't end up making it in the Constitution. And I laugh because both of them actually ended up being implemented anyways here. So the original First Amendment here proposed setting a formula for the size of congressional districts based on population. So get this, the concern was that if Congress, particularly the House of Representatives, got too large, that would essentially become a de facto oligarchy. Not saying that it is, I'm just saying that was a very astute prediction on their end there. We actually do have rules now for establishing the size of congressional districts. So that was essentially put into place. And then the original amendment to propose keeping Congress from giving themselves pay raises, requiring it instead be done by the next Congress. That ended up becoming, I believe, my face is in the way, so I can't see. I think it was the 26th Amendment. So it ended up getting passed later on. So the idea there is that Congress can't give themselves a pay raise in the year that that they're in session. That it has to wait for the next Congress, but because of the incumbency effect, which we'll talk about, it's usually the same Congress here. So the states rejected these first 2, but the remaining 10 were separated from the remainder of the Constitution to become what are known as the Bill of Rights here. And these are often also referred to as our civil liberties. So, what became the actual First Amendment at the real 1A here is Congress shall make no law establishing respecting an establishment of religion, prohibiting the free exercise thereof, abridging freedom of speech or the press or the right of people to peacefully assemble and to petition the government for redress of grievances. Good God, that's a lot going on in the First Amendment here. So we're going to unpack sort of different elements of this here, and we'll go ahead and start with everybody's favorite dinner time conversation with relatives, religion. So you've also, people often talk about, the concept of separation of church and state in the Constitution. Well, that phrase actually isn't in the Constitution anywhere. Actually came from comments that Jefferson made to a group of Baptist church leaders in Virginia back in the day there. But what we do have is known as the Establishment Clause, and that clarifies that the government cannot establish or restrict the free expression of religion. And in terms of how this is applied by the courts for various things, so obviously there's different sort of situations. Again, I mentioned I grew up in Texas, where there is a mega church on every corner, and oftentimes, for instance, high school graduations would be held at one of these mega churches because they had the seating capacity for that. And generally speaking, that's legal, and we'll talk about the reasons for it and kind of when it's legal. And the test that's applied by the courts is referred to as the Lemon test. Now, this establishes 3 criteria for evaluating government interaction with religion and whether or not it violates the Establishment Clause. So, is the interaction, is the primary purpose of this assistance secular in nature? So, if a church offers or rents out their auditorium for a public school event, in most cases that's a secular event, unless they insist on, reading a prayer or baptizing people during the middle of a graduation. Then, generally speaking, it's considered secular, and so it passes the Lemon test. The assistance does not promote or inhibit religion. So if said church said, you all, so I'm doing my Texas voice, y'all all welcome here, except for you members of whatever faith. other faith that isn't what our church is here. Yeah, that would deny or would promote or inhibit religion, right? Because you're now essentially utilizing a public institution for kind of religious purposes here. There's a lot of weird things going on with the Supreme Court, these days, and we'll talk more about that later. But there was recently a case where a high school football coach in Texas was leading his football team in a prayer after every game, and you had a student who sued, basically saying that he that it was a Christian prayer and that he was not Christian, and so but he felt that if he didn't participate in the prayer that he'd be sanctioned for it, that he might not get playing time and stuff. It ended up being that case was just heard not too long ago, and they settled on behalf of the coach who was fired because he insisted on giving the prayer. So that's one case there where it ended up passing the lemon test, and the court decided that the guy's prayer of the game did not promote or inhibit religion because he wasn't requiring all students to do it, and he was able to make the case that he wasn't punishing students for not participating. No excessive entanglement between church and state. So obviously this is a subjective measure here, and there's been a variety of different cases here. We'll talk about a few of those as it relates to the 10 Commandments here in a bit. I'd be really impressed if you got the reference of the movies piece here. So Kevin Smith, I would say, was a famous director in the 90s, but that was when he produced his best stuff, the original Clerks. It's all kind of gone downhill from there. He has a great movie called Dogma. That's what this is from. If you like religious alliteration, that's a good movie to watch. Oh, the duck's here. Good. But if the founding fathers were these pious Christian men, why would they want to prohibit the establishment of a national church? Actually, a very good question here. So really they weren't, or at least not how we think of it. So, look, this is a contentious point here, and there are historians, depending on your perspective, that disagree with here. I'll lean on David Holmes, author of a book called Faiths of Our Founding Fathers. I always struggle to say that. So he makes a distinction between Christians and deists among the founding fathers. So while a small group are principally Christians or deists, the largest percentage of the founding fathers identified as Christians, but adhered to deist practices. So this included sort of the deist perspective was more of a belief in sort of God and the Judeo-Christian concept of God, but not necessarily a belief that God was someone who was involved in our day-to-day lives, someone that you sort of interacted with. From the deist perspective, and again, I'm a little outside my league here because this is probably more a religious philosophy course content. I always like to use a comparison of God, basically flipped on a light switch, which started a machine that created Earth and humanity, all these things, but then walked out of the room. And so when we talk about the founding fathers, and a lot of people have this notion of them as, again, these pious Christian men, their Christianity occurs in a little bit of a different context than what we would sort of understand. Now, obviously, you did have very evangelical style Christians among Sam Adams would be a good example of that. But there was a heavy concern among the founding fathers, and a good share of them, of religion becoming, essentially excessive and being sort of forced on people. And so that's why we sort of get this, what we call separation of church and state, but the establishment clause more specifically. So I mentioned the 10 Commandments. This, I think, actually illustrates just sort of the subjective nature of the lemon test and determining what violates sort of the establishment clause. So there was actually, in 2005, there were 2 cases related to the 10 Commandments heard by the Supreme Court on the same day. So on the left there, you got in the 2005 case of McCreary County versus the American Civil Liberties Union. The Supreme Court ruled that the placement of a 10 Commandments monument in front of a courthouse was unconstitutional. In this particular case, they had placed it in the, I think, the center of a foyer that, it was a central piece when you walked into the building there. And they went back to the comments made during the ceremony celebrating it, where one of the officials said that this is the embodiment of ethics in Christ. At its dedication ceremony there. So based on those factors, the court said, this is too strong an entanglement between church and state. Interestingly, on the same day, they heard another commandment case there in 2005. This was Van Orden versus Perry. It ended up allowing a 10 Commandment statue or monument on Texas state capitol grounds. So in this case, the monument had actually been donated by a secular group. I believe it was an organization that was focused on child delinquency, and it was placed in essentially a garden of monuments where it was innocuous. It was kind of there with a bunch of other ones, so it wasn't sort of centrally located. So in that case, the Supreme Court said that does not violate the Establishment Clause. You can go ahead and do it. So let's move away from religion, thank God, literally, and let's go to freedom of speech here. This concept of freedom of speech, and when can we express things? So the interesting thing is that it is restricted. You can't say whatever you want, sort of wherever you want. And the main sort of standard that was utilized is what we call the clear and present danger standard. So in 1917. Supreme Court took up a case of two socialists who were arrested for passing out literature in basically among recently drafted soldiers. So they were in line getting ready to be essentially drafted for World War I. They passed out literature saying, don't go to war, this is illegal, immoral, all these other things. In Schenck versus the U.S., the court argued that during a time of war, that these two socialists' speech represented a clear and present danger. That was sort of akin to, we obviously use the example, if you yell fire in a building and there's no fire, that it creates this clear and present danger. In the case of this situation, they said that, motivating people to, illegally violate their draft orders would put the United States at, at risk of attack or of not being able to fulfill its military obligations. Oh, that's my dog back there walking around. Hey! The cat's here too, so you may be treated to the dog going after the cat here in a bit. In Brandenburg versus Ohio, 1969, the court also clarified a bit and included speech that incites or creates imminent lawless action as capable of being restricted by the government as well. So now if you get up on a podium and tell a bunch of people, we're going to storm the Capitol, that creates that creates a clear and present danger as well. And that speech can be restricted as well, and you can be held criminally liable for that. Obviously, I use that example because as it relates to the January 6th events, there were claims made against some individuals who spoke during that event, claiming that they essentially incited the events, subsequent events that would follow. Freedom of speech in schools is interesting here. So in 1969, the big case on this is Tinker versus Des Moines, said that public schools can restrict student speech if that speech creates a disruption to the learning environment here. So I'll clarify here in just a second. So in that particular case, students were wearing black armbands in school to protest the Vietnam War. The school suspended them. The students sued. The court agreed with the school and said, look, these black armbands had caused a major disruption to learning. It was distracting students from sort of doing their thing and going to class because it was causing such an uproar. There was a more recent case, actually, 2021. Mahoney Area School District versus BL. Excuse me. BL, her name was Brandy. I don't remember her last name. Was a cheerleader suspended from her squad. So she posted, and for the sake of, being true to academia and truth and whatever, I'll just say she said fuck cheer to friends on Snapchat because she had actually been either cut from the cheer squad or didn't make the cheer squad. Anyways, the court ruled, so the school district suspended her. Hey, stop. The school district suspended her and said that, it had created a learning distraction. Well, it went through the court system, and the court ended up agreeing. And the precedent that was established there was that actions that you carry out even outside of the classroom can disrupt from the learning experience. So obviously Brandy was angry because she posted it on Snapchat. She didn't post it even during school. She ended up removing it, but it had created such an uproar that they basically said you can't try out for cheer again, sort of in the future. So lesson learned. Duck's back here. He says, so Mrs. Skeptical Duck and I were on a Spirit Airlines flight. I'm so sorry. Recently, where they made her turn her T-shirt inside out because of a vulgarity on the back. I would expect no less. Who do I talk to in order to sue them for violating my free speech rights? As I note here, first of all, I don't think Spirit Airlines would even care enough, so I don't even know if this is legit. So very important point here. If I had an elevator ride worth of time to leave anybody with any knowledge about our U.S. government system based on sort of our most common misinterpretations of it is this. Civil liberties are only protected by government agencies. The Bill of Rights only pertains to your interactions with government agencies at whatever level. It could be at the town level, at the state, the federal government here. They do not regulate interactions for the most part with private organizations here. So in nearly all cases, a private company has no obligation to recognize your civil liberties. Now, a notable exception there is, we have federal laws that say, you can't, discriminate. You can't refuse to serve someone because they're African American, for instance, or other forms. And in some places, sexual orientation is a protected class here. But a private organization, if an airline says, we don't like what your shirt says, you have no legal recourse because it's a private entity. Now, if you were to go to school and, like we said, if you wore a shirt, so a public school, which is a public institution, you might have a case. Again, it would be sort of measured up against whether or not it caused a disruption to the learning environment there. So if you walk away from this class with any one thing, you will, particularly young people, as you engage in online arguments with people over political matters over the course of your life, you'll hear people all the time say, Target violated my free speech, I'm going to sue. You can't sue Target. It's a private company. Generally speaking, what happens within their walls is up to them with some caveats. It's back again. Wow. So not so fast. Wasn't a bakery recently sued for refusing to bake a cake for a gay couple's wedding? Doesn't that contradict what you just said? Yes, it's complicated. And it still isn't really resolved. So there's this cake shop in Colorado, Masterpiece Cake Shop. They had a gay couple that come to them and said, we'd like a cake for our wedding. And other than maybe two grooms on the top of the cake, I don't know what about the cake made it, hetero versus homosexual in orientation. I don't think anything. But the cake. The guy who owned the cake company said, I'm not going to do this. It violates my religious beliefs. The Colorado Civil Rights Commission had found that the baker was in violation of the state's anti-discrimination laws. So the state of California actually had a law saying you can't, discriminate based on someone's sexual orientation. Well, the cake shop owner basically, sued through the federal court system, saying this was a violation of his First Amendment rights there. The court kind of punted here. They didn't. They sort of sided with the bakery, but not on the merits of the constitutionality of the issue, but rather, claiming that the Civil Rights Commission was not neutral to the parties here. So it was really more of a technicality. There's actually a case being heard right now in the Supreme Court that is supposed to sort of establish the precedent on this. And in this case, so this one's interesting. Someone who owns an internet, who does websites for weddings, is suing. They haven't actually been asked by a homosexual couple to create a website for their wedding, so it's a weird thing because it's based on a theoretical, and so the court's actually hearing that case right now, so we may get a ruling in the next 6 months or so on this matter here. So just the point to drive home is it's a little bit complicated as to the extent to which a private company can or cannot sort of violate civil liberties, particularly as it relates to specific laws that are passed on these grounds. So let's switch to freedom of the press. We're almost 20 minutes in. We're still on the First Amendment here. Fortunately, the other ones go a little quicker here. The Bill of Rights protects the freedom of the press, and it restricts plaintiffs' claims of libel and slander here. So the idea is that the founders realized that we needed a press to be able to hold politicians and the public certain members of the public accountable, and that if we allowed them to be sued every time they printed something that turned out to be not correct, then we wouldn't have a healthy system of the press, and they wouldn't be able to check for corruption and other sorts of things here. The big case here is New York Times v. Sullivan. Focused on press directed at public officials and ruled that a plaintiff must demonstrate that a lie was told with actual malice by the publishing agent. And so this actually came up during, you may recall, the election machines. So you had, various members of Trump's entourage claiming that there was massive corruption, that this company that created these, voting machines was basically allowing the results to be changed, sort of, within the machine. There was no evidence here to support this, and generally speaking, the courts in these cases. So, one of these, the manufacturer of these voting machines, actually, filed a suit against one of these individuals and won a substantial amount of money because the court said there was no evidence to substantiate this, and it seemed that this person was doing this out of actual malice. And that was an interesting case because you saw, particularly in right-wing media, but I'm sure this is influencing left-wing and other media as well. All of a sudden, they've changed their tactics a little bit, because now if you can legitimately be sued for some of these grandiose claims that you make, if the plaintiff can argue that you did it out of malice, then that sort of changes things here. Another case, Obsidian Finance Group v. Cox. The court ruled that bloggers have the same protections as journalists and are not liable for defamation except due to negligence. So as I point out here, your friend's mommy vlog is treated as real and legitimate journalism because nothing makes sense anymore. All right, the Second Amendment. So a lot of people are pretty familiar with the Second Amendment here, but it reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the history of the Second Amendment is interesting because up until 2008, no gun control restriction had ever been struck down on Second Amendment grounds. And the reason being was that the court had ruled that the militia referred to in the Second Amendment was a state's National Guard. And that as long as a state had an active National Guard, there was no reason for public citizens to, have weapons as it pertained to the Second Amendment, and thus states or local governments can impose, more or less any restrictions on firearm ownership here. For 2 centuries, the courts had agreed with that, but then we ended up seeing a change after 2008. And that was based on the Heller precedent. So the case of District of Columbia v. Heller concerned a D.C. law that established that prohibited handgun ownership within D.C. So in that particular case, Heller was a D.C. special police officer. He'd applied for a permit to keep a handgun in his home, and he was denied. So in a 5-4 ruling, so again, it was very, very close here, the Supreme Court upheld a lower court ruling that the Second Amendment does, in fact, protect an individual's right to self-defense in their home, and really sort of upended that National Guard precedent there. This was later affirmed in McDonald v. Chicago that confirmed that states must also respect the Heller decision. Courts have generally, though, it is important to note, have found that Second Amendment rights are not unlimited. And I had in here, I have to edit this because I have November 2021. There's a couple cases moving through the court system that challenge that. One was actually the bump stock ban. So a bump stock is a device that essentially turns a semi-automatic weapon into a fully automatic weapon, or gives it the capabilities of that. That had lower level courts that supported the ban of that. A recent ruling suggests that those are permitted by the Second Amendment. So this is constantly sort of evolving there. The Third Amendment: no soldier shall, in time of peace time of peace, be quartered in any house without consent. Look, that's not something that happens very often. It's not really litigated, but it does come up in issues of this assumption of a right to privacy, which is not explicitly sort of laid out in the Constitution, but it's implied from certain things, such as the Third Amendment. As an example, Griswold v. Connecticut was cited to protect a couple's right to use contraceptives, as it had been used to protect privacy rights. In fact, it was Texas, for the longest time had anti-sodomy laws that essentially made, sexual relations between 2 men illegal. That was struck down based on actually the Third Amendment here, which implied a right to privacy. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And if you get a warrant, it has to be based on probable cause. So a good example here is the case of Katz versus United States, Katz with a K, set a precedent for reasonable expectation of privacy with regard to government search of persons or property here. So we will talk about a case at some point, and I can't remember when, that specifically deals with search and seizures. So there is an implied right to privacy. So an officer pulls you over, he says, you know what, open the glove box. I want to see what's in there. The police don't have a right to just open your glove box unless he has probable cause. And if he doesn't, if you, sort of push back on that, then he needs to come back with a warrant, which means that officer has to go to a judge and say, look, I smelled marijuana in the car, and so I had probable cause to believe that there was marijuana in the vehicle, which would allow me to search the glove box or the trunk or that sort of thing. So, and that occurs obviously within your home as well. So the police can't search your home without a warrant. There are a few caveats and exceptions. You've had cases where a child has gone missing, and the police will identify registered sex offenders in the neighborhood, and that actually gives them probable cause to search those homes during those situations. So there's always sort of caveats there, but ultimately, you have a right to privacy with regard to search and seizures unless there's probable cause. The exclusionary rule in privacy here. So the exclusionary rule sets out that evidence obtained illegally in relations to the Fourth Amendment is inadmissible in criminal trials. So if, there's a few cases around this, but if the police find something in your glove box, but they had no real reason to search it, then that evidence might not be admissible in court there. Matt v. Ohio, 1961, confirmed that the Fourth Amendment applies to state and local governments as well. The courts have ruled that there's no expectation of privacy when information is made public. So if I post something on Facebook admitting to a crime, that there's no privacy there. If the police force is scouring Facebook and they find that message there, then that's probable cause to to search my property as it relates to that crime there. Carpenter v. U.S., however, did rule that you have an expectation of privacy related to your cell phone, even though the data is shared with your cell phone company there. So the courts essentially need a warrant to be able to get records or access records on your cell phone. Now, even this has gotten a little sketchy because in the recent changing of the laws with regard to excuse me, abortion access, there was a case I believe it was in Kansas, where a woman, not Kansas, somewhere around there, where a woman essentially had posted something on or had private messages on Facebook rather, with a conversation with someone to get access to, I don't remember if it was a abortion pill. I think it was abortion pills. The police reached out to Facebook to secure those private messages. Facebook agreed. According to Facebook, they did it because they believed that they didn't understand the circumstances, that they believed that there was probable cause. Anyways, this woman was arrested based on that. So that's a case I'm sure that I'll go through the court system here. The Fifth Amendment. No person shall be held to answer for a capital, otherwise infamous crime, unless an indictment based on a grand jury. When blah 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 blah. I'm skipping forward here. So the Fifth Amendment says basically makes double jeopardy illegal, not the game show, but basically being tried for the same crime twice. So it's the reason O.J. Simpson can go around saying, yeah, I killed my wife, and he can't be tried again because he's already been found not guilty there. The other thing the Fifth Amendment is known for, obviously, is that you don't have to essentially incriminate yourself. So when somebody says, I want to plead the Fifth, you have the right to keep silent. Of course, it's included in the Miranda rights when the police arrest you here. Not that I would know. Wink. No, I've never been arrested. And then also, Fifth Amendment says private property won't be taken for public use without just compensation. And so that gets to eminent domain, which I'm going to talk about on the next slide here. So, in addition to establishing the right to remain silent, the Fifth Amendment also creates the basis for eminent domain. So, this is the authority that the government has at the state or federal level or local level to basically seize private property. And they could do so as long as they provide just compensation for it. And if it's for a public good. And so this has been argued through the court system quite a bit here. So I give the example here. A state can seize land for use in expanding a highway or to build an oil pipeline. They can decide, like, we need this pipeline to go through your farm and we're going to take a piece of it. They would have a harder time, doing so to allow, Amazon to expand a warehouse. There have been cases where that's because they can argue that, well, Amazon's going to create so many jobs that there is a true public good for this. But if they're just putting up another Starbucks and they need to take your land to do it, that's probably not going to get approved. The image on the right here, I always find it funny. So I used to fly through Narita in Japan outside of Tokyo on my way to China for business trips quite a bit. Don't go there that much anymore. But there's this small farm that's literally in the middle of the airport. If you want to go into Google Earth, you can see it. And it's not the United States, so eminent domain laws are different there. But essentially, the airport there in outside of Tokyo was not able to secure that land from the private owners. And so it basically just stands there as a giant screw you to the airport. In fact, they have messages in Japanese to that point, but it's right there in the middle of the airport, which is quite funny. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy a speedy and public trial by an impartial jury. So obviously, this is very important to protecting the rights of the criminally charged and have the assistance of counsel for their defense. And so, if you can't afford an attorney, one will be provided for you. Again, in the Miranda rights. This is based on the Sixth Amendment. So you have that right to counsel. Just based on statistics, roughly 2/3 of those charged with federal and state criminal charges, or 2/3 of those charged with federal crimes actually use a public defender, so a free attorney, and then 83% of those charged with criminal offenses at the state level. So basically 4 out of 5, more than 4 out of 5, use the services of a public defender that's provided to them free of charge. The Seventh Amendment says that in suits at common law where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved. So basically this says at the federal level in civil suits, if you want a jury trial for your civil matter, you are constitutionally provided that. So this one's interesting because it's one of the few cases where the incorporation doctrine is not applied. So the incorporation doctrine is essentially the idea that anything that's laid out as rules for the federal government in the Bill of Rights basically applies to lower levels of government as well, more specifically the state. Now, this is the one exception. So at the state level, you don't have a federally protected or constitutionally protected right to a trial in civil matters. Now, you do have it for criminal matters as it pertains to the Sixth Amendment there. The Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment here. So this is where the cruel and unusual punishment piece comes here. 8A is typically cited in arguments related to the death penalty and other forms of criminal punishment, although the death penalty has not been found to be unconstitutional. That's why it's still carried out. You had a 1983 case of Solem versus Helm. Argued that a punishment cannot be in excess of the crime committed there. So to try and keep essentially punishments proportional here. But the court later reversed this ban on disproportionate sentences in the 1991 case of Harmelin versus Michigan, and argued that there are some situations where a punishment needs to be necessarily cruel. So this has been applied in a lot of cases. For instance, people who are caught with, child pornography, for instance, are charged with, account for each, picture, for instance, and they could get a sentence of, 300 years or something, which, some have argued could be perceived as excessive given, a person not committing a physical crime against another person. Obviously, the others in the courts have argued that there is a need to make this necessarily cruel there. That's the standard. But obviously, this subject, is very pertinent to the sort of variance in the ways that criminal punishments are handed out. When I created these slides, it was relatively recent to the case of a truck driver in Colorado had received a 110-year sentence for a brake failure accident. So his brakes failed. The court argued that he knew something was wrong with his brakes and could have done more to stop it here. So he ended up crashing into a bunch of cars, killed 4 people. On the flip side, he had a drunk driver about the same time, killed a 24-year-old mother, and ended up receiving, sort of probation. So this concept of the fairness of criminal charges is really a subject for a more detailed class in criminology here in the legal justice system, but certainly an important one as it relates to the 8th Amendment. All right, 2 more to go here. The 9th Amendment, the enumeration of the Constitution of certain rights shall not be construed to not deny or disparage others retained by the people. So basically what the 9th Amendment here is saying is that just because something isn't detailed in the first 10 amendments doesn't mean it's not a right that is inherently applied to people. So in this little comic here, I give you the example. Nothing in the Constitution says you have the right to fly an airplane. But the government can't necessarily tell you can't, because it is implied that we have freedom to move about the skies and all that sort of thing. You need a code word this week, so I will give you one here because I appreciate that the airplane in this picture is a Mooney. Good for you if you knew that. Mooney. Mooney aircrafts. Just give me Mooney as the term. It was an airplane that was made in South Texas for many years. They're very fast. Their fuel tanks have a tendency to leak, which I don't need to tell you is a bad deal. So Mooney, Mooney, use that as your code word and supply that for me today. And then finally, the 10th Amendment here. The powers not delegated to the United States by the Constitution or prohibited by it are reserved to the states. This ends up being hugely important here. So basically, it's the basis of the claims of state rights. That states can essentially enforce laws or put things in their own constitutions as long as it doesn't violate anything in the U.S. Constitution. And it gets really sort of tricky here. This was specifically called for by the Anti-Federalists who wanted to assure, again, okay, everything we haven't covered here, those powers are reserved to the states, again, to maintain states' rights. Another critical thinking interruption here, it's from Howard the Duck, which if you grew up in the 80s, you would have seen this. And I use this because you have to be stoned to appreciate this movie, probably. So even though marijuana is legal in many states, I'm not allowed to buy it with a credit card. What gives? I spent hours researching this due to a distinct and noteworthy lack of any personal experience. That's my point there. States can legalize marijuana sales within their state, so long as no interstate commerce is occurring. So that's why if you go to Colorado and you purchase marijuana there, they'll tell you when you leave the airport, you cannot leave this state with this marijuana. Your credit card company, though, however, does not engage in intrastate commerce. They engage in interstate commerce. If you remember what we said before, interstate commerce can be regulated by the federal government here. So the federal government, is frustrated, saying, damn it, we can't stop Colorado from selling marijuana. But what we can do is stop credit card companies from being able to process marijuana transactions and sales. And so I've been told by people that if you purchase edibles or those sorts of things at an approved shop, that you need to bring cash or at least a debit card or something like that to be able to pay for it, but usually cash. Again, I have no idea. So again, this all comes back to the Commerce Clause as established by the Interstate Commerce Act. So it gives the federal government the authority to regulate industries that cross state lines. There was a relevant case here, Gonzalez versus Raich, 2005. The court upheld that. So basically what happened is the federal government came in. This woman was growing weed in California. She had the proper authorization in California to grow that marijuana and to use it herself. But the federal government came in, and I think in black helicopters, swooped down, burned all of her weed, made sure that they weren't downwind of it. And so she sued. The court argued that her marijuana could indirectly affect the interstate trade of marijuana, and thus state laws would not apply. So interesting case there. More recently, the Biden administration has cited the Commerce Clause in establishing, vaccine mandates, right? Trump state bans on such mandates. So when state governments tried to ban vaccine mandates, the Biden administration had, more or less successfully used the Commerce Clause to argue that that was the purview of the federal government here. There's a lot of concern about the Commerce Clause and basically an argument that it inherently violates the 10th Amendment. So you see Clarence Thomas here, a notorious conservative justice on the Supreme Court, saying if Congress can regulate this under the Commerce Clause, then it can virtually regulate anything. And the federal government is no longer one of the limited and enumerated, powers here. So opponents, proponents of states' rights are very concerned about the utilization historically of the Commerce Clause to give the federal government more power here. So long video, coming up on 40 minutes here, but that was a lot to cover. And I know at some points I was a little bit facetious here, but that's a lot to cover. There's a lot of relevant sort of cases, and I've heard some people mention an interest in sort of law and constitutional law. This really is sort of fascinating as it relates, to your civil liberties. But again, if I was to drive home one point, it's that these generally pertain to your relationships, with the government. It's the reason that you can be fired by a private company for reasons that a public company wouldn't be able to, sort of fire you for and that sort of thing. So just keep that in mind. Next lecture, we'll go into the remainder of the Constitution, and particularly the parts that lay out sort of the key institutions, the three branches of our government, and then also the other remaining amendments there. So thanks so much.